Good evening, one and all. I am Advocate Anand Kumar, practicing in Delhi High Court. I am going to be your host and the moderator for today's session. My team AP Legal Chambers and I welcome you all for this 11th webinar of the series titled Is Timely Justice the Heart and Soul of the Indian Constitution? An analysis by our special speaker, Mr. P.V. Saravanaraja, Advocate on Record, Supreme Court of India. At the outset, we thank the participants for the continuous support and patronage. As always, we keep this as a request from our end to all the participants. Kindly mute your audios and if possible, disable video from your end too. The session is a completely moderated one. And once the presentation of our special speaker gets over, APLC's APLC and the question answer session would follow. If you have any questions to ask our special speaker, kindly drop it in the chat box, and if time permits, all your questions will be answered by our special speaker. Today is the auspicious occasion of Guru Purnima. From the bottom of my heart, I thank all my gurus who have shaped me in one way or the other. I am happy to share with you all that we have crossed our first milestone of 10 webinars plus 550 followers in FB and nearing 200 subscribers on YouTube. We have over 15.5 hours of content on YouTube. If you have missed it, any of our previous videos, please watch it on YouTube and encourage us. With each passing webinar, we are trying our level best to improve and elevate one step further. Intense research, coordination, man management, data analytics, etc. goes before organizing and hosting these webinars. We are evolving too. We have been watching the recordings of our previous webinars again and again and do error corrections. We try to give something new in each of our webinars. We come up with new segments, renowned special speakers, and interesting topics. We want to give our participants nothing but the best. We owe the entire credit of this webinar to our special speaker, Saravanaraja sir. After all, we are just setting up a platform for the special speaker to connect with the participants and vice versa. For all those who are attending our webinars regularly, I am sure you all might be knowing us. For those who have come here for the first time, we are Team AP Legal Chambers, a new age law firm in Delhi NCR with a branch office in Chennai. We started our journey in the year 2017 with the vision of providing plenary services to our clients and to resolve their legal issues. APLC's portfolio covers a broad spectrum of specialized services including domestic and international taxation, constitutional laws, IPR, energy law, commercial advisory, arbitration, and corporate compliances. We started organizing these webinars out of our passion for law, and due to the extremely positive response from our participants, we are organizing these webinar series on every Thursdays and Sundays. As always, once the special speaker's presentation gets over, we shall be having the segment called APLC's APLC, Ask the Popular Learned Counsel. We have prepared a few questions from our end and we would be asking them to our speaker. I am sure it will be both interesting and informative. In today's webinar, we shall be covering the interesting subject of timely justice, which is one of the prerequisites as enshrined in our constitution. Our special speaker here tries to analyze whether it is the heart and soul of our constitution, and at the end of the presentation, we shall have a clarity on this subject. As you all know, this is an evergreen topic. So, let me introduce our special speaker for today's webinar. Mr. P.V. Saravanaraja is an advocate on record, practicing in the Honorable Supreme Court of India for more than 12 years. He has dealt extensively in cases pertaining to civil laws, criminal laws, constitutional laws, etc. He recently submitted his PhD in law Law at GD Goenka University. As one of the young members of the bar, he had an opportunity to deliver a lecture on the topic Principles of Res Judicia at Library Number 2, Supreme Court, conducted by Friday Group, which is an academic group of the Supreme Court advocates. This was held in the month of February 2019. Our special speaker has been a resource person for conducting workshops on drafting and filing procedure of public interest litigation. He has been conducting this for the final year students of Lloyd Law College in the Greater Noida. He was awarded as the best paper presentee and his paper adjudged as best paper of the conference at the Commonwealth Legal Education Association CLEA Conference 2018. He has done his Masters in Contract Law from the University of Madras. He was a university rank holder BABL 2002 to 2007 batch. When he was a final year law student in the year 2006-7, he served as a law clerk for a period of 1 year in the Honorable Judges of High Court of Madras. He has also represented India in the year 2007 in the William C. Wiss International Arbitration Moot Court competition held in Vienna, Austria. When I approached him for the webinar, he wholeheartedly agreed for coming on board. Dear participants, please join me in welcoming our special speaker, Saravanaraja sir, to the webinar. I welcome our special speaker to APLC's webinar. I am so excited to listen to his speech. Welcome on board, sir. Over to you.
Thank you so much. And happy Guru Purnima to one and all. Today is the 11th webinar series being conducted by AP Legal Chambers. We know 11 means numerical number 1, 1. Generally, number 1 refers to leadership, positivity, and dynamism. And when double 1 joins, the positivity, leadership doubles, multiplies. Therefore, they have started with 1. Now they have reached, AP Chambers reached 11, which is a great victory. I strongly believe that their successful webinar depends on, their strength depends on their hard work. Their strength depends on their constant support getting from the audience. So therefore, I wish them all success, and I'm very happy that I'm also part of this webinar. I thank the organizers as well as the wonderful audience. Now, let me come to the topic. Is timely justice a heart and soul of the Constitution? That is with the question mark. That is the question before us. So to present this paper, let me quote Socrates, the Greek philosopher, who was considered to be a father of Western philosophy. He said, examine yourself and examine others, question others. Unexamining life is not worth living. Therefore, taking guidance from his quote, I wanted to present this paper by raising 5 questions before this August gathering. First question is, what is the historical background of the evolution of justice? Number 2, is timely justice a heart and soul of the Indian Constitution? Number 3, are we getting timely justice? Number 4, what are the problems and solutions to get timely justice? And 5th question is, what is the conclusion? What is the result that we get out of these presentation? So with these 5 questions, let me move on to the first question. That is, what is justice and what is the historical background of justice? For this, now we are in 2020 Now we need to travel back to understand its history. I want to categorize into three types. One is ancient India, number two, medieval India, number three, modern times, that is during British era. So to travel back to ancient India, I asked our organizer Anand to help me to go back to ancient India. So he immediately accepted and provided me a time machine today. With his help, with the help of time machine, let me travel along with all this audience and go back to ancient India and to understand how the concept of justice evolved. So now, understanding this, let us go back to ancient India. In ancient India, law is otherwise called as dharma. Dharma is based on Vedas, Smritis, Puranas. Dharma is a Sanskrit term which means righteousness, which means truth, which means moral, which means pious. But nobody is there to define what is dharma is, but we can give only the meaning of it. The same question was arose in the mind of King Udist, the eldest son of Pandavas. He asked this question, what is dharma, to his grandfather Bhishma. And Bhishma said, it is one of the most difficult questions to answer what is dharma is. But whatever you do, which is good for others, which is upliftment of living beings, is surely dharma. That is how we define what is dharma is. So whatever you do good, that is dharma. And why this concept of dharma is introduced? Because of the problems that are being faced by human beings. As a solution, dharma was introduced. So what was the problem? And where was this problem arose from? The natural problem of human beings arises from his own instinct, human instinct. So now what is the question? The question is, what is human instinct? What is his nature of human being? Number one, a desire. Whatever the action that he do, the reason behind that is desire. And desire is the cause of sorrow. That is what our Lord Buddha also said. So we can define or we can categorize these desire into two types. One is bodily desire. Number two, material desire. So to understand what is bodily desire is, we can take a classic example of Ramayana. And the classic example, the character is Ravana. Ravana, one of the most powerful king ever lived on this planet. He was a great devotee of Lord Shiva, and he is man of wisdom. He was a learned person. He knew the Vedas, inner meaning of it. And he ruled Lanka, and Lanka is a wealthy country. But he invited death because of his bodily pleasure of abducting Sita from Lord Ram. What do we get or what do we gather from this? Whatever the powerful human being you may be, but if you choose a wrong path, when you go against dharma, then you will invite your own defeat. You will invite your own death. That is what the example of Ravana is. And coming to the second desire, that is material desire. For this, the classic example is Mahabharata. Mahabharata is a fight between brothers, son of Pandavas, and this side Duryodhana and his brothers. They fought each other. Why? Because Duryodhana did not offer a share of his land to his own brothers, son of Pandavas, because he wanted to enjoy the entire land without distributing to his own brothers. Therefore, he did not follow the path of Dharma. Though he had the great warrior Karna along with him, the immortal person Bhishma along with him, Dronacharya, who taught to all the students, Guru was with Duryodhana, and all the powerful persons were with Duryodhana. But what is on this side, that is Pandavas, only Dharma, and where Dharma is, Lord Krishna was also there. So the Kurukshetra war took place. Finally, Duryodhana died. He lost his land. And Pandavas, they won. So what is the moral of the story is, from Ramayana and from the great epic Mahabharata, the moral of this story is this: where the truth is, there is Dharma. Where there is Dharma, there is God. Where there is God, there is His blessings. Where there is His blessings, there is victory. And victory is nothing but Dharma. That is what law is. So with this, we have crossed the ancient India, and let us take the time machine, let us move on to medieval India. That is, during the Muslim period was there. And I wanted to discuss under this topic by taking guidance from an article written by a retired Supreme Court judge, Justice Markandeya Kharju. In his article, he wrote who is his ideal judge. He said his ideal judge is Judge Sirajuddin. His Lordship Markandeya Kharju had been a judge of Allahabad High Court, thereafter Chief Justice of Madras High Court, thereafter Chief Justice of Delhi High Court. Then he was ultimately elevated as a Supreme Court judge. He would have seen many judges in his lifetime. He would have read so many books concerning the life of judges. But the one judge, according to him, an ideal judge, what is that special quality that he possessed which others did not? The interesting question is it not? So the same question arose in my mind also. Then the history goes like this. In 1490, a book was written on the history of Bengal by Saul's author on discussing about Sultan period. The Sultan is considered to be a king, and he was considered to be a representative of God on this planet. So the facts of the case goes like this. When king himself practicing the archery, accidentally it wounded a boy who is a son of a widow. Immediately the widow knocked the doors of Judge Sirajuddin. That Sultan caused wound for his own son. So there was a thought process in the mind of Judge Sirajuddin, thinking that if we summon Sultan to appear before the court of Sirajuddin, definitely judge will be punished by Sultan. But if we do not summon Sultan to his court, if he fails from his duty, if he fails to discharge his duty, certainly one day he has to answer the court of God. Therefore, fear of God prevailed over fear of Sultan. That Sirajuddin decided to send his court officer to summon Sultan. When court officer went to Sultan's court and officer conveyed the message that he was summoned by Judge Sirajuddin, king rose instantly and he concealed sword in his garments and he came to the court of Judge Sirajuddin. Judge Sirajuddin did not bow his head, did not pay any respect to Sultan, though he is the king of that entire country, Bengal state. Sultan, immediately Judge Sirajuddin put a question to Sultan. Sultan, you wounded boy by your own archery, by your own arrow. Therefore, you pay a suitable compensation or otherwise you will be put behind bars. Immediately, Sultan turned towards the widow and said, I will pay the suitable amount. I do not want to face this sentence. So he turned towards widow and asked for suitable compensation. And she quantified. The amount was paid then and there, immediately. Then Sultan said to Judge, I have paid the entire amount. Then Judge Sirajuddin asked widow, are you satisfied? Widow said yes. Based on her assent, the case was disposed of. After the disposal of the case, Judge Sirajuddin rose from his dais and came towards Sultan. Sultan told Judge Sirajuddin, I am very much proud of you, Judge, because you are not afraid of that I am Sultan, I am the king of this state. But still, you have administered justice. If you had not administered justice, if you had not summoned me, I would have chopped your head by this sword. So he took his sword out of his garments. For which Judge Sirajuddin replied, I am also very happy, king, that you obeyed my summons. Otherwise, I swear in the name of God. He took out his whip and said, if you had not answered my summons, this whip would have made your back blue and black. So from this, what we gather, king may be supreme, but law is king of kings. And fear of Sultan, fear of God is prevailed over fear of Sultan in the mind of Judge Sirajuddin. That is how he became an ideal judge, not only in the mind of his lordship Markandeya Kardju, in my mind also. I strongly believe in your minds also. Such a judge we require, even in today's time also. Now, we have travelled from ancient India, medieval India. Now let us move on to British era, modern times. How the court evolved. In 1773, we all knew that East India Company came to India as traders. Thereafter, they started occupying the country. Because of their expansion, in their growth, the law were enforced through royal charters by the King of England. In 1773, Regulating Act was promulgated by King of England. By this promulgation, Supreme Court was established, firstly in Calcutta in 1773, thereafter in 1800 in Madras, and then in Bombay in the year 1823. Point to be noted here is, at that time there were no high courts. But in the year 1857, there was a transfer of power from the East India Company to the Crown. So Crown took the control over India, and in the year 1861, Indian High Courts Act was enacted, and they abolished the Supreme Court, which was already functioning in Calcutta, Madras and Bombay, and they established High Court at Calcutta, Madras, Bombay, Allahabad, and subsequently Patna, Lahore. So by this establishing these high courts, they made the High Court as a supreme power to decide all those cases which arises within their jurisdiction. But the appeal against those high courts is usually an appeal preferred before the Privy Council, that is in Britain. So the need was felt, why should we appeal to Privy Council, which is far away situated from India? Therefore, they felt that they can appeal from the High Court to any other court like Federal Court that may function within the territory of India. That is what they felt. And ultimately, Federal Court came into functioning in the year 1935 by the Government of India Act 1935. And it kept on functioning till the enforcement of our Indian Constitution, that is on 26th January 1950. So this is how the present Supreme Court came into functioning from crossing all these historical events. Now we have covered ancient India, medieval India, and modern times, and how the Supreme Court came and established and how it is functioning today. So my first question is completed with this proposition, that what was the historical background of evolution of justice. I conclude with this three types, and now let me move on to the next question, which is the most important. Is timely justice a heart and soul of the Indian Constitution? I want to answer this question in the following ways. Our Indian Constitution is considered to be the mother of all statutes. We derive the entire nation functions under Indian Constitution, and the Constitution is broadly classified into legislature, executive, and judiciary. We know legislature has the power to legislate law for the welfare of human beings, living beings. Executives, one who executes those enacted laws for the welfare of the poor and people at large. Judiciary is the custodian of the Constitution. It keeps a check both on the legislature as well as on the executive to see the fundamental rights of the citizens and other statutory rights are protected. That is why Supreme Court is considered as a custodian of the Constitution. So with this understanding the judiciary and its effective position, let us understand what is the concept of justice that is enshrined in our Indian Constitution. Number one, let me take you to the preamble of our Constitution. What the preamble says? We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic, and republic, and state shall secure justice, most important, justice. What sort of justice? Social justice, economic justice and political justice. The concept of justice is based on the distributive justice. So now let us understand what is social justice. Social justice means doing greater good to the good number of people, to the people at large, at the same time without violating any of the accrued legal right with the individuals. Now, what is economic justice? Economic justice means that there should not be any inequalities among the people based on economy. Political justice, which gives equal opportunity and of status. So this is what the preamble says. And I would like to refer to Keshavananda Bharati case, which is popularly known as fundamental rights case or basic structure doctrine of basic structure case. In this case, the issue before the 13 judges bench is this: whether the parliament can amend the Indian constitution by virtue of Article 368. The judgment of the Supreme Court said, of course, Parliament can amend the constitution under 368, but without disturbing the basic structure. Now, let me ask myself the question, what is basic structure? So the Supreme Court has sorted out what is basic structure is, and it is inclusive nature. It has not defined, it is of inclusive nature, depends upon the facts, case to case. The majority of the judgment said the objectives mentioned in the preamble is also a basic structure. So now we have seen justice, social, economic, political is the objectives mentioned in the preamble, and that preamble has become a basic structure of the constitution as per Keshavananda Bharati case. Now, moving on to the next article, Article 14. It guarantees right to equality before law and equal protection of law. Article 21, which guarantees you a right to life and personal liberty. So the importance of Article 14 and Article 21 can be understood by referring to one case, Saravanaraja AOR case. This case is otherwise called as right to speedy trial case. The facts of the case is this: number of children, women and men, they were put in jail for number of years. One point is to be noted here: they were pre-trial prisoners. Trial is yet to commence, but they were languishing in jail for more number of years. It even went to the extent of exceeding the sentence which they could have got by their conviction. Therefore, the Supreme Court said, see, you cannot take somebody's personal liberty by putting him in jail for number of years. This is absolutely a violation of Article 21 of personal liberty. And they said you can take away personal liberty only by due procedure of law. And the due procedure should not be arbitrary, it should be fair, it should be reasonable, as held in the Maneka Gandhi case. Therefore, in Saravanaraja AOR case, these prisoners' right, personal right, was taken away, and it's a clear violation of Article 21. Therefore, right to speedy trial has become one of the facets of Article 21. what a speedy trial means. Speedy trial will lead to speedy justice. And speedy justice is nothing but timely justice, which is a topic for discussion today. So that is how timely justice becomes a facet of Article 21. Now moving on to a very interesting article, that is Article 32. Article 32 is the most important article, and it is considered to be right to approach the Supreme Court or enforcement of fundamental right under Article 32 is itself a fundamental right. When Dr. B.R. Ambedkar was questioned that according to B.R. Ambedkar, which is the most important article, B.R. Ambedkar replied by saying that I can say Article 14 is important because I did not enjoy during my lifetime the equality. Or I can say Article 21 personal liberty and it guarantees life. But those articles become meaningless unless and until without a remedy provided under Article 32. So there should be a right and there should be a institution to provide remedy also. Therefore, according to Dr. B.R. Ambedkar, Article 32 is the heart and soul of the Constitution. So according to Dr. B.R. Ambedkar, judicial remedy is the heart and soul. Judicial remedy means the institution, the purpose of the institution, judiciary, is to render justice. Remedy, that is justice, to the litigants. Justice should not be a delayed justice, should be a timely justice. We all know a famous saying, justice delayed is justice denied. So I took the guidance from Dr. B.R. Ambedkar to choose today's topic. Is timely justice a heart and soul of the Constitution? I replaced timely justice in Article 32 because judicial remedy is the heart and soul. The purpose of judicial remedy is to render justice. Render justice should not be a delayed justice, should be a timely justice. Therefore, the birth of this topic has come from Article 32. And now moving on to another very interesting article and very important article, that is Article 142. This is an inherent power vested with the Honorable Supreme Court. And to my knowledge, I could not find any parallel power vested with any of the courts, any of the high courts. What does 142 say? 142 says, the essence of 142 is, it is an inherent power vested with the Supreme Court, and the power vested with the Supreme Court, they can pass any orders to do complete justice. So complete justice, in my understanding, it includes timely justice. Timely delivery of justice is a part and parcel or integral feature of Article 142. Therefore, this is most important, timely justice is. If the institution do not render timely justice, that means it is not rendering complete justice, and it is a violative of Article 142 itself. Therefore, taking guidance from the preamble, justice, social, economic, political, then taking guidance from Article 14, Article 21, Article 32, Article 142, we can very well say, with the pronouncement, with the assistance, with the guidance from the Supreme Court pronouncements, that is in Keshavananda Bharati case, Husainara Khatun case, in many other catena of judgments, we can safely conclude that timely justice is the heart and soul of the Constitution. So with this, I am completing my second question. Now coming to the third question, are we getting timely justice? If not, What are the serious consequences? The answer is, it's an open secret to all, to the entire universe. We are not getting timely justice. We are getting a delayed justice. Why is it so? What and the serious consequence is this? Problem of delayed justice leads to these problems. What is the problem? Generally, people approaching the court for what? Because they are victimized by somebody's act.
Sir?
So they want to get remedy or suitable remedy from the court. So already they approach the court with a wound in their heart, and they need to pay fees to the lawyers. So they wound their hands also. Then ultimately, when there is a delayed justice, it wounds their soul. And what happens is, because of the delayed justice, the people will lose faith in the system, and they will take law into their hands, and there will be a lawlessness in the society. There will be a law and order problem, and there will be a complete chaos. So there should be the ability from the lawyers, there should be a nobility from the judges, and the institution should provide serviceability to the people at large. Then we can bring back the glory of the institution. Having understood the third answer to the question also, that there is a delayed justice. Now moving on to the fourth question, that is, what is the problem and what is the solution for this delayed justice? So now, where is the delayed justice? Is it happening in Supreme Court or in high courts that are functioning in various states, or in district courts? That is a question staring at my face. But it's a vast subject. Within a short span of time, I cannot cover everything. Therefore, Supreme Court, being the apex court, being the top court, being a role model court for the entire courts in India, so let us examine the apex court alone in today's topic. So the problem of delayed justice from the Supreme Court that we are going to analyze today. So Supreme Court is the top court in our country, and it exercises various jurisdictions. One, original jurisdiction. Under original jurisdiction, we have Article 32. Anybody whose fundamental right is violated, they can approach the Supreme Court under Article 32. Section 25 Civil Procedure Code, that is original, that also gives power to the Supreme Court to entertain original jurisdiction. It's a transfer petition, 25 CPC or 406 CRPC. It's a transfer petition where you can approach the Supreme Court directly when you want to get a transfer of any case pending either in district court or high court from one state to another state on any reasons. So that is how the original jurisdictions, and Article 131 is also there. The original suit, when there is a dispute between two states. So these are the articles which gives right to the parties as well as to the Supreme Court to exercise its original jurisdiction. Now coming to the appellate jurisdiction. Appellate jurisdiction, there are a number of high courts. When somebody, an aggrieved party, out of the judgment passed by the High Court, if he wants to prefer an appeal, he has to approach the Supreme Court. So appeal may be under Article 133 or Article 134 or under Article 136. Or statutory appeals are also provided. under section 38 of the Advocates Act, you can approach Supreme Court. So that is how the statutory appeals and the appellate jurisdictions lies with the Supreme Court. Thereafter, advisory jurisdiction under Article 147, if I am not wrong, President of India can seek advice from the Supreme Court on the question of public importance. So that is advisory jurisdiction vested with the Supreme Court. Then review jurisdiction. When there is an order passed by the Supreme Court at the stage of SLP, then remedy is review against the dismissal of SLP, review jurisdiction. Thereafter, curative petition. After dismissal of review, we can prefer a curative petition. So these are the various jurisdictions vested with the Supreme Court. Now, to understand the problem of delayed justice, we can refer to the annual report issued or published by the Supreme Court of India in the year 2018. According to the report, Supreme Court said there are 56,000 and odd pending cases in the Supreme Court. And if you analyze why there are so many pending cases in Supreme Court, we get the answer is the delay attributable to the docket explosion of special leave petitions. The problem lies with more number of cases being filed before Supreme Court under Article 136. So what is 136? Is 136 is a special leave sought by the Supreme Court. With the leave of the Supreme Court, you can prefer an appeal against the order. Order may be an interim order or a final order, maybe from the tribunal or a district court or from the High Court. Such a wide power vested with the Supreme Court. But one notable word is most important in Article 136 is discretionary power. Underline or highlight the word discretionary power. The Supreme Court feels in its discretionary that there is grave injustice happened to the aggrieved party, or when there is a substantial question of law involved, or there is a question of law which concerns the public at large, they can, by exercising their discretionary power, they can entertain special leave petitions. So special leave petitions cannot be treated as a matter of appeal. How do we file under section 96 CPC first appeal or section 100 second appeal before the High Court? It cannot be treated as another appeal. It is not a statutory appeal, a right vested with the litigant, but it is a discretionary power vested with the Supreme Court. That is most important. But the more number of cases are being filed under 136. Maybe frivolous cases also filed. The classic example I can give you. This is my personal experience. When I sat in the Supreme Court for my matter to be heard, there were few other matters were also listed earlier. One of the matter went and came up before the court, Supreme Court. An advocate stood up to address his arguments before the court. Before he could open, judges asked, "We are going to impose a heavy cost on this petition. You tell us how much cost." I was sitting there and I did not know what is the facts of the case. And I felt in my mind, why judges are so harsh? Here is an advocate has to represent Is his professional duty to represent a client? But judges are saying that we will impose cost even before before he could open his mouth. So I was wondering. Later on, I found the conversation between the court and the advocate. Advocate has preferred SLP against the dismissal of a application by the High Court. That application dealt with application for listing of his matter at the yearly listing of matters. So application was moved before the Honorable High Court. Honorable High Court dismissed. Against that dismissal of the order which rejected yearly listing, that came up before the Supreme Court. But the concept of 136 is substantial question of law. Where is the substantial question of law involved in the dismissal of yearly listing application? Where is the question of public importance? Where is the question of grave injustice? Therefore, the Honorable Court rightly pointed out to the advocate that we will impose heavy cost. Therefore, he did not argue his case. On the contrary, he withdrew it, but there was not cost imposed on him. In the same manner, we can understand the importance of 136, how the frivolous cases are being filed and piled up. So we have understood the main reason for the delay is number of SLPs. 80% of SLPs are filed and more number of cases are also dismissed. And how do we give solution to these problems? How can we reduce the backlog of cases? How can we reduce the pendency? How can we take away the burden of the apex court? I have 5 solutions. Number 1, we can nip the frivolous litigation at the first instance itself. So the solution is, we cannot come out with a new system and abandon the existing system and replace the new system with the existing system. That is not my solution. My solution is, my humble solution for your kind consideration is, just now we have seen how the frivolous cases are filed, the dismissal by the High Court against the earlier listing. How this could have been avoided without even approaching the Honorable Court for hearing, without even wasting the judicial time. There is a power vested with the registrar that he can go through the petition. The petition does not reveal the reasonable cause. The petition does not reveal the injustice. The petition appears to be scandalous and frivolous. That petition can be rejected by the registrar itself. That is guaranteed. That is the power vested with the registrar under order. Just a minute, let me tell you. Order 15, Rule 5 of the Supreme Court rules. Because the Supreme Court has got the power to frame its rules under Article 145. Based on this rule only, they have framed the Supreme Court rules, and under Order 15, Rule 5 of the Supreme Court rules, which says the registrar can entertain the petition which is frivolous and dismiss the petition without even getting it heard by the honorable judges. But the remedy against that dismissal is, a litigant can appeal to the Supreme Court against the dismissal order passed by the registrar within 15 days. If this power had exercised by the Honorable Registrar, the SLP against the order dismissal of early listing would not have reached the Honorable Court. So this power, though it is there in the rule book, but I have my own doubts whether it is put in practice. And the second solution is National Court of Appeal. Because the concept of apex court and the concept of top court is to render a judgment of public importance and lay down a law for the entire country. Because we all know that Article 141, when there is a judgment pronounced by Supreme Court, becomes a law of the land, and it has a binding effect on all the courts. So it becomes law of the land. In Vishaka versus State of Rajasthan, though there was no law on the point sexual harassment at workplace, there was a gray area, but still Supreme Court invoked Article 142 and framed guidelines. What was the duty upon the employer, the employee, and how the sexual harassment has to be prevented. So those guidelines framed under Article 142 has become the law of the land under Article 141. So the concept is to declare law for the entire country and to decide the most important interpretation of the constitutions, and they are not meant for deciding rent matters. They are not meant for deciding these frivolous cases. So therefore, a National Court of Appeal would be a better option, and it can be established in the eastern, western, northern, southern zones. And the factual finding aspect will become final at the stage of Court of Appeal itself, and those cases will not approach the Supreme Court. Therefore, the Supreme Court can easily spend its judicial time with the most important question of law, which concerns the public at large. Where did I get this idea? The establishment of National Court of Appeal is there was a judgment pronounced by the Supreme Court itself, and they expressed their worries. Frivolous cases are being filed under 136, and we could not spend judicial time for evolving law, for interpreting constitution, for rendering judgments of public importance. So the Supreme Court itself came out with a solution, National Court of Appeal. The judgment is Bihar Legal Support Society versus Chief Justice of India and another. This was reported in 1986, Volume 4 SCC, page number 767. The facts of the case quite interesting, because a writ petition came to be filed by Bihar Legal Support Society. This society is a registered society. The object of the society is to render free legal aid to the poor and disadvantaged people. So they filed a writ petition. The background of this writ petition is on 5th of September 1986, the bail petition came to be decided by the Supreme Court late night Saturday on 5th September 1986 to consider the bail petition of two big industrialists, Their names are Shri Lalit Mohan Thapar and Shri Sham Sundarla. So their petition came to be decided in the midnight. And how that event is related to this Bihar Legal Society case. Considering the urgency shown by the Supreme Court, this society preferred a writ petition by saying the Supreme Court should decide the bail petition immediately, as how they decided the bail petition of those two industrialists. Therefore, how the writ is being treated by the Supreme Court, at the same part, even poor people should also be treated, and their bail petition, an anticipated bail petition, should be decided immediately. So this was their prayer. And the case came up before the Supreme Court. And did you notice the other side was the Chief Justice of India and others? That is the case law. Bihar Legal Support Society versus Chief Justice of India. And the then Chief Justice was Justice Bhagwati. This petition came up before the bench. Bench appreciated the writ petition, and they said the Supreme Court is meant to render justice not only to the rich people, but also to the disadvantaged people, also to the poor people. Because poor were deprived of justice for so many years. Therefore, the Supreme Court leaned towards the weaker section and they rendered justice to them. That is why the concept of PIL originated. Because even before the origin of PIL, the most important is to maintain a petition under Article 32 is locus standi. What is your locus? How is your right violated? Otherwise, if you are not able to establish your locus standi, your petition will get dismissed. But the concept of PIL diluted the locus standi. Even the deprived people, even the weaker section, those who are economically backward, can approach the Supreme Court by writing a mere letter to the Chief Justice or to any other judges. So letter can be entertained as a PIL. Even a suo motu petition can be taken by Supreme Court. So that is how the PIL concept evolved to render justice to the weaker sections, those who are deprived from approaching the Supreme Court. So those concept of PIL was also discussed in this Bihar Legal Society case also. And judges, they said, we cannot frame guidelines or we cannot give directions to the administrative side of Chief Justice, saying that these are the petitions to be decided then and there. But on the judicial side, we deem it fit to say that whatever and whenever the bail petition or anticipated bail petition is preferred, be it rich or be it poor, if it is preferred before the Honorable Supreme Court, the Supreme Court, considering the urgency, an advocate can have a mentioning before the court explaining its urgency, and if they could satisfy the bench that there is urgency in that matter, then and there it will be listed. And they appreciated, the judges appreciated the endeavor, right-spirited society. They recorded their appreciation. At the same time, they also expressed their consent for National Court of Appeal in this judgment. So, if the listeners find time, kindly go through this judgment. It is one of the most important judgments, and how the judges appreciated the writ petition, and they have explained what is the concept and what is the need for the Supreme Court, and explained that they are bound to decide the constitutional cases, not the frivolous cases, and they explained the need for court of appeal. So from this judgment, I took a guidance, and I also reiterate humbly that we need a court of appeal to be established. And Vasanta Kumar case is also pending, and advocate Vasanta Kumar, he has also prepared a case for establishment of National Court of Appeal. Notice issued by the Supreme Court to the Union of India, and it is pending for consideration before the Honorable Supreme Court. Now, coming to the another suggestions, ad hoc appointment of retired judges under Article 128. Because whenever we discuss about the backlog of cases in the Supreme Court, the pain that is expressed by the people are Supreme Court judges, and the Supreme Court is closed for vacation. We have summer vacation for 1.5 months. We have winter vacation for 15 days, and you have holy holidays for a week. Thereafter a week holidays for Diwali, and so on, so on. So therefore, they express their grievance. The vacation should be curtailed, but Honorable Supreme Court judges, they are overburdened. We cannot even feel their burden. Reason is, consider Monday and Friday are generally considered to be the admission matters, and nearly 50 to 60 matters are listed before them per court. So judges has to read 50 briefs. We find it difficult as an advocate. We find it difficult to read a single brief. Judges, they need to read 60 briefs, and SLP 60 SLPs in a day. That means they need to read 1,000 pages. So that is the story of Monday and Friday. And think about Tuesday, Wednesday, Thursday. Final hearing matters listed. Miscellaneous matters are listed. Nowadays, few admission matters are also listed. And think about Saturday and Sunday. They have to, whatever the cases that they have heard, they need to pronounce judgments. So they need to go through the written submissions. They need to go through the SLPs once again and come and render judgment by dictating to the stenographers. Thereafter, give it for circulation to the brother, his lordship. So the Saturday, Sunday are also spent on judgments. Then again they need to read yet another 60 SLPs that are coming up on another Monday. So they are completely occupied. They cannot even lift their head from the SLP paper book. This is what Justice Indu Malhotra her lordship said in the Friday group at library number 2. So much burden rested with them. So considering those vacations, number of holidays that they go for, even Supreme Court lawyers also, the answer to that question is, we can have retired Supreme Court judges, those who are residing in Delhi, we can ask them to occupy during the vacations, and the Supreme Court can have an effective functioning as that of a normal court. The provision is also there under Article 128. Only thing is, ad hoc retired judges has to be appointed by the Supreme Court, by the Chief Justice of India, with the approval of President of India. And this article was put to test. An interesting story was there. In the year 1972, when the Keshavananda Bharati case was heard by 13 judges, the retired judges were taken back to the court, like judges' names are C.A. Vaidyanathan and His Lordship Justice I.D. Dua, D.U.A. They were brought back to the Supreme Court and they were made to sit along with the newly appointed judge Justice A. Alagiri Swami. So they were occupying the bench and deciding cases for some couple of months. But only thing is, the disturbing factor is the retired judges or were already seniors to the newly appointed judges. But after their retirement, if they were brought back to the Supreme Court, they lose their seniority. Newly appointee sit as a presiding judge and retired judge, he sits as a brother judge. So he loses his seniority. But again, this article can be explored and we can put to test and we can make the retired judges to come to certain terms and we can utilize their rich experience, their rich knowledge in law for getting timely justice. So this is my another option. And thereafter, fourth option is when we draft SLPs, SLP has got a format. List of dates and events, synopsis, list of dates and events, then impugned judgment, then SLP with question of law and grounds, and then prayer. I would like to humbly propose taking guidance from the earlier decided case that frivolous cases like SLP preferred against the dismissal of High Court order dismissing the application for early listing. According to me, it's a frivolous case in my humble submission. Therefore, those cases can be decided by the registrar himself. I would like to propose, like list of dates, like synopsis, there can be one more page added to it. The page can be named as Amicable Settlement page. How we call synopsis, list of dates, there can be Amicable Settlement page. In that, the petitioner can say that this case can be settled subject to the respondent agreeing to certain terms and conditions. If that is there, then Supreme Court, while considering the petition, they can issue notice on the settlement page also. If the respondent also agrees to the terms, then immediately matter can be decided then and there. I got this idea by my own experience. My experience goes like this. There was a transfer petition filed by one lady before the Supreme Court seeking transfer of a petition which was pending before the Family Court Madras to Family Court Bangalore or any other state. The ground which she took was the Family Court judges were biased because the respondent is a wealthy man, influential man. Therefore, I wanted a transfer from Madras, Family Court Madras to Family Court Bangalore. When the matter, I appeared for the respondent. When the matter came up before the Honorable Supreme Court judge, his lordship immediately posed a question to the advocate for the petitioner. This transfer petition was filed a year back. Now the situation could have changed in the family court because there might have been a change in the judges. Therefore, your petition has become frivolous, and the petitioner has made unnecessary allegation against impartial judge. These were the observations made by the Honorable Supreme Court judges. Immediately, the advocate for the petitioner understood the mindset of the judge and immediately said, "My lords, your lordships may refer the matter to mediation. Therefore, we mediate, and there are number of cases pending between both of us, we will settle it. So the case was referred to mediation, and mediation took place for 2 times. Mediation failed and yet to see the light of the day before the Honorable Supreme Court. So from this, what I would like to submit before you all is understanding the mindset of judges, thereafter asking for matter to be referred to mediation is something that tactics, delaying tactics. Otherwise, if the case was decided then and there, could have been dismissed. So, to avoid the dismissal, the amicable settlement terms was introduced by the advocate for the petition. As per my humble submission, if the amicable settlement page was put up already in the be it SLP, be it transfer petition, in the first page, the respondent could have given a reply to the terms. If settlement failed at the first instance, then they would have decided, the Supreme Court judges could have decided the case on merits. So the delaying tactics would have been avoided. So therefore, this amicable settlement page can be introduced as the first page in every petition. Therefore, the settlement terms will not crop up in the midst of the arguments. And finally, we are running short of time, and there are questions to be asked also. So now the last and not the least, my humble submission is strength of the judges should be increased, because lot of pending cases now, 31 honorable judges are there. They are overburdened. So if we increase the number of judges, the number of cases will also be disposed of at the earliest. But those who want to criticize the number of judges to be increased, they have a point to say. If number of judges are increased, there will be a divergent opinion on certain question of law, and it is very difficult to adhere to the judicial discipline. Though every concept has own advantages and disadvantages, we have to ignore the disadvantages and we have to take the advantages. And number of judgments, the Supreme Court can prescribe. Judgments can be sought by through letter circulations, but there are, to my knowledge, there are no prescribed limit for seeking adjournments through letter circulations. We can put a limit. Therefore, unnecessary and frivolous adjournments can be unnecessary and frivolous adjournments can be avoided. Now, we have seen, going back to all these 4 questions, we have seen the evolution of justice. We have seen whether the timely justice is the heart and soul of the Constitution. And we have seen, are we getting timely justice? And we have found the problem is backlog of docket, explosion of SLP, and we have come out with certain suggestions. And let me come to the 5th final question is, what we have gathered out of this presentation? What is the conclusion? What is the fruit of this presentation? What is the moral of this moral story behind this is? I would like to say that humbly. Timely education will save the mankind. Timely monsoon will save the crops. And timely medical treatment will save the life. And timely justice will save not only the victims but also the institution where the large number of people expects and believes, has enormous faith in this system. And I would like to conclude my presentation with the quotation of Swami Vivekananda. Swami Vivekananda said, take a one idea, make that one idea your life. Think of it, dream of it, and live on that idea. Let your brains, muscles, bones, nerves be full of that idea and leave all other idea alone. This is the way to success. From this, I take the guidance. The success of the judicial institution will be our only concept is timely justice. We cannot attribute the timely justice to be rendered only by the judges, but also all the stakeholders. Timely justice should be our idea, and for which we all should work for it. And with this, I conclude. I am truly honored because of the opportunity that was given by AP Legal Chambers and the patience, audience. I am truly honored and I am very happy. And the request, my humble request to the listeners is AP Legal Chambers are doing wonderful, and the A stands for Anand. Anand itself denotes immense happiness, and he is spreading immense happiness among us all by spreading knowledge. If he is going to give 1,000 rupees, he will be deprived of 1,000 rupees. But if he is going to give knowledge by conducting these webinars to all, his knowledge multiplies. Therefore, AP Anand, by giving knowledge to all, is spreading happiness to all. I request all the listeners to subscribe the channel AP Legal Chambers and kindly view their videos also that is uploaded in the YouTube that will give immense knowledge. When mind is full of knowledge, it is only a storehouse. When that knowledge is shared with others, it becomes a lighthouse. AP Legal Chambers has become a lighthouse and spreading the knowledge of law to one and all. And their videos has become immortal. Thank you so much. Thank you, one and all. Thank you.
Thank you very much, sir, for your wonderful presentation. I am also humbled by your appreciation. It is just a small drop of water in the ocean. We are trying our level best. But coming to this topic, you have done a wonderful presentation, sir. You have covered the past, present, and also you have given suggestions for the future. You have not only covered whether it is the heart and soul of the constitution, but also given your opinions and recommendations for actually implementation of a speedy justice. We are very much thankful for you for your wonderful presentation, and I am sure all the participants who have attended here and also all the people who will be viewing your video on YouTube will definitely get knowledge and benefit out of your presentation, sir. Thank you. This is an evergreen topic. Each time whenever a speaker presents about this topic, he or she will only confine themselves to a particular section, but you have covered a vast area. You have gone from the past and also to the future as well. We cannot say whether this will be the end of this discussion, but definitely these are all the points which will definitely give an opportunity for all the stakeholders to deliberate and discuss on this and come up with a better solution. Thank you, sir. Now, with your permission, we will be moving on to the next segment called APLC's APLC. Yes. Sir, first question. You are an advocate on record and you are dealing in Supreme Court every day. As we all know, yato dharmas tato jayaha. Where there is righteousness, there is victory. This is the motto of our Supreme Court of India. Sir, do you think is the motto is really followed in the letter and spirit, or just it is available on the motto? What is your opinion, sir?
In my humble opinion, the Supreme Court not only just in motto it says where there is dharma, there is victory. According to me, the Supreme Court in letter and spirit have time and again serving the purpose and helping the people at large. We can gather not from the judges' conversation or from their speeches, we can gather from their judgments itself. Volume of number of judgments they have evolved law, and they have rendered justice to the litigants at large, and they have understood. For example, Justice Putuswamy case, right to privacy was never a fundamental right guaranteed to any of the citizens. But they said it is a natural right and it is being recognized by a constitutional right as a fundamental right, and it has become a facet of Article 21. Therefore, in letter and spirit, they implement it and they do wonders.
Thank you, sir. It was wonderfully answered. Just clearing the mindset of the common people. Moving on to the next question. So again, there is a general mindset among common people that when they go for litigation or when they enter a courtroom, the justice which they are going to get is a very time-consuming one. Some of them even feel the justice would not be rendered even till their lifetime, the verdict. Sir, what is your opinion, sir? Do you recommend the common people to approach the court of law for all the problems, or there should be some kind of an alternate dispute resolution which can be adopted by the people for speedy and quick justice, sir?
Your question leads to the topic for today, that is timely justice. We chose this topic because there was no timely justice and there is a delayed justice. That is the reason why we have taken up. Having taken up this issue, the Supreme Court or any other high court or other district courts also were functioning successfully from its establishment, and we can always suggest for mediation. For example, I can give a case where we can understand this problem very well. The wife wants to file a divorce case against her husband. She goes and files a case straight away before the family court, and husband receives a notice and he makes his appearance. Thereafter the matter is referred to the mediation. So already the litigative mood is there with the wife. Therefore, there is no sanctity attached to the mediation. In my humble opinion, if at all any divorce case, any cases to be filed, especially in the family matters, there should be a mediation at first instance. The mediation is failed, then her petition to be entertained. So there cannot be any litigation at the initial stage, and mediation cannot come up in the mid of the litigation and cannot have its journey. So mediation is most important, and we have lost the capacity to listen to our elders. That is our problem. The human problem is we should listen to the elders. In the initial stage, the joint family means joint family, brothers, sisters, and grandfathers, mother-in-law, father-in-law. It is a joint family, and they had tolerance level. Today, the joint family means the union of husband and wife. Husband and wife, they successfully stay together under one roof, they become a joint family. So therefore, we should listen to the elders. If we listen to the elders, they have experience, they will point out, they will lead us in a right path. We don't listen to the elders, we immediately come to the court and we spend our time. Our life itself is very short, and we should lead such a short life, a meaningful life, not in litigation. Therefore, I suggest is better to sort out the issues at the family stage itself. Otherwise, if you want to take up to the court, if the issues are very serious, then go for the mediation first, then litigate. This is what my humble suggestion to a question on.
Thank you, sir. Wonderful suggestion. First, settle it in the family level itself. Then, if that doesn't work out, take it up in a mediation level, and just use the courts as the last resort. If there is no other alternate left, use the court. Thank you, sir. It was excellently answered. Now, moving on to the next question. Sir, why do you feel people in other countries get quick justice compared to India? The disposal of cases in other countries are comparatively very quick and fast compared to how it proceeds here in India. Do you think is there any kind of disparity when you see places in other places and compare it with India, sir?
Yes, I understand. Definitely, there is a vast difference between us, that is India, with other countries like America, Canada, or UK. Because we differ with the largest population that our India has. It is the second most populous country in the world. Number two, we have got vast diversity and different culture, different region, religion. Our country is a unique country on this planet, according to me. And in other countries, they don't directly come to the litigation because the litigation is very, very expensive. Even an American woman wants to get divorce, she will think 100 times before approaching the court because she don't want to burn her hands by paying fees to the lawyers. Here, you will find lawyers charging from 1 lakh to 10,000 also. Litigants can approach depending upon their financial capacity. So according to me, the more number of population and the advocates are available at any cost, this makes the more number of litigations in India than other countries.
Wonderful, sir. You have completely given a different perspective to this question, sir. Thank you very much. Sir, I would like to tell you one thing. We had set a question as to asking you, we wanted to ask you this question as why, even though as a personally a practicing advocate and a student of law, I was having an answer to give to my friends, those who are into non-legal field, but they were not convinced. But the answer which you gave today for the reason as to why our Supreme Court and High Courts go for vacation, that was really convincing and it was really a wonderful answer, sir. So do you think complete justice, in your opinion, do you think complete justice is served considering Article 142?
According to me, Article 142 is a unique power vested with the Honorable Supreme Court, and you will not find any parallel power in other courts. So complete justice should include timely justice, and all the stakeholders like judges, litigants, lawyers should understand the importance of timely justice, and very soon, sooner or later, complete justice is already being recognized as a timely justice. What we are seeing in theories will come soon in practice, and we will enjoy the fruits of litigation.
Yes, sir. Thank you very much, sir. Sir, please, last question for the day. Please share your success mantra for our participants, sir. What is success according to you, or what would you like to share to our participants?
Success mantra is human life is very short, and make the human life very meaningful. For example, one wants to make a history, has to read history. We have got wonderful sons of the soil on this planet, like Gandhi, Mahatma Gandhi, Swami Vivekananda, Lord Buddha. They were the great sons of the soil. But today, we have not lived in those times, but we can gather information through their textbooks, through their biography, through their autobiography. Therefore, I request the entire audience, the successful mantra is, even after your end of your life has to become a history, and you should find a place somewhere in the book rack. Therefore, lead it very meaningfully. The mantra I would say is, always be active, always be hardworking, and always have the quality of perseverance. Never give up. Never, never, never give up. And you should have faith in yourself. That is most important. You may have 100 faiths in 100 gods. That is immaterial. You should have faith in yourself. That is most important. You can do wonders, and you can also place your name in the history and have that confidence. That is my humble mantra to our entire audience.
Thank you very much, sir, for this wonderful session. From the bottom of my heart, I thank you for this coming on board of APLC. And with this, we wrap today's session. my team and I personally thank our special speaker and all the participants for participating in this event. There are other exciting webinars coming up, and we will be shortly releasing the posters also. Kindly subscribe to our channel AP Legal Chambers for further details in YouTube, and also please follow us on Facebook for the posters. And with this, I Ms. Syed Ahmedi, I think your question will be answered by our special speaker, and I will get the answer for you in the through mail. Because we are running short of time. Thank you very much for asking the question. And with this, we wrap this session. And it is Anand signing off. Thank you, one and all. Have a great week. Thank you.
Thank you, Anand. Thank you.